Michael Rickenbach, Rickenbach.
Sir, what is your position again? What is your position and your occupation?
I am a forensic chemist examiner within the laboratory division of the Federal Bureau of Investigation.
Your Honor, we would reassert that Michael Rickenbach has been previously designated as an expert witness in the area of forensic chemistry.
That's correct, he has.
Ladies and gentlemen, the certification still stands. You may continue.
Sir, I'd like to direct you to your a report you did in this case dated July 6th of 2009. Do you have that with you?
Do you have a copy or?
Yes, I have a copy I can give you. May I approach the witness?
You may.
Before counsel, could I take a look so I can pull my copy of it?
After you've had a chance to review it, sir, let me know.
I'm ready.
Were you given certain items of evidence to inspect and do tests on, sir?
Yes, I was.
Okay, and what were those items?
These items we designated with certain Q numbers. They were a bottle, liquid within that bottle, a syringe with a needle on it, and liquid within that syringe. There was an unknown substance within a bottle.
Objection. Object to reference to items that are not.
I can't hear you.
I'm sorry. Object to testimony about things that are not in evidence. Those items are not in evidence. We could approach them. Discuss them.
No. Are they in evidence, Mr. Baez?
Well, they're in the possession of the sheriff's
No,
department.
no. Are they
May we
in
approach,
evidence?
Judge? I'd like to.
They're not in evidence. Objection sustained, but you can approach.
Dr. Rickenbach, I'd like to.
Just a second.
I apologize.
You may proceed.
Dr. Rickenbach, I'd like to direct your attention to the report that you issued on December 11th of 2008. Do you have that with you, sir?
If you'd have a copy.
Sure. Did you receive certain items from the Orange County Sheriff's Department?
We received items. I received items from my evidence control unit, which in turn received them from the law enforcement agency. Yes.
And could you tell the ladies and gentlemen of the jury what those two items were for that report?
The items related to this report were one car seat. We designated as item Q47, and an item reported as being a steering wheel cover, item Q48, according to this laboratory report.
And Your Honor, I believe by previous stipulation, these two items were retrieved from the Pontiac Sunfire from the, with the tag number. Is the tag number on your report?
There is no information about a tag number on this report.
The Pontiac Sunfire that belonged to Miss Anthony.
What says the state?
Your Honor, we're just looking. We think that the steering wheel cover may actually be.
You have to turn your microphone on, Mr. Hurst.
We don't have any objection to proceeding with that stipulation. We're going to check. We think that the steering wheel cover may actually be marked, and the defense can move that into evidence, but we're going to check and see if we did have that marked. But he can go ahead.
You may continue, Mr. Baez.
And what were you asked to test these items for, sir?
I was asked to test for the presence of volatile substances, particularly chloroform.
Okay. And can you tell the ladies and gentlemen of the jury what your results were?
That chloroform was not identified on either one of those pieces of items.
And why would you test a steering wheel cover? What's the purpose of that?
I'm not sure why it was requested. It was just when the items come in with a certain request from a contributor, we perform those tests.
Okay. Were you informed at any time that the purpose was to see if chloroform had been on someone's hands
Objection.
that drove? May I finish the question? Chloroform that might have been on someone's hands would then possibly transfer to the steering wheel cover?
Objection,
Don't
hearsay,
answer the
and
question,
relevance.
sir, until I rule. Mr. Ashton?
Objection, hearsay, and relevance.
Sustained
it would
on
go
hearsay.
Your Honor, would go to his items that might contribute to his opinion.
Sustain.
And the other item that you tested was exactly what again, sir?
Besides the steering wheel
Yes,
cover was
besides-
Q47, which is a car seat.
The child's car seat,
Yes.
and you found no chloroform on that.
Chloroform was not identified on that item. No.
Okay. Now, I'd like to direct you back to your previous report on July
May I,
609.
I'm sorry, may I clarify? Chloroform was not identified on the samples that I took off of that item. I cannot say for sure that I did not analyze the entire car seat. I took cuttings that were representative of that car seat that I thought, and no chloroform was identified on those cuttings. I want
Understood.
to clarify that, please.
Understood. And were you also given another item to inspect for chloroform? I believe that's noted on your report of July of 09.
The original report that you.
Correct, the first report I showed you. I'm going to refer to it. What were you given, sir, to inspect?
According to this report on July 6th,
Yes.
you want me to list all the items?
No, just the specific, if I can look at your report again, I can give you the Q number, so we don't address anything.
You have a new request, if the item is marked, it be put into evidence prior to testimony about it.
Well, he can list what he's looked at, Bill. He can't test, he can talk about what he's seen, but he can't talk about any results until they go into evidence.
May I have a moment with Mr. Ashton?
You may.
Judge, at this time, I would move HR states including HR evidence.
Was it marked for identification by the state, but not entered by the state?
Yes, it was.
Yes, sir.
It be received in evidence as defense numbered.
Number 32.
Without objection from the state.
Number 33.
Sir, were you given a doll to also check for chloroform?
Yes, a doll was submitted for analysis.
And did you conduct the examination on the doll to see if that had the chloroform on it? And can you tell the ladies and gentlemen of the jury what those results were?
I did receive a doll for the determination if chloroform volatile chemical was present on that item. I took a sampling of that item, and the analysis of the samplings, chloroform was not identified.
I have no further questions for Dr. Rickenbach at this time.
Cross-examination.
As to the examination of the doll, was there not an early indication of the presence of chloroform that you had to go and get another doll to check? Am I remembering the right item?
When analyzing the doll, there were indications of that chloroform may be present, but in very, very small amounts. I requested that a similar doll be submitted. That was not available. A coworker submitted a doll that she had. I analyzed that. Again, very small amounts of chloroform, related product, and so it just was not enough for me to render a decision that chloroform was identified on that item.
So there was an indication of chloroform, but you,
Object about on this and request a sidebar.
You may. You may continue.
okay, if you want to go ahead and finish your answer about your exploration of the chloroform issue on the doll.
What is commonly done is that a negative control is usually run with the same sample matrix. So in this case, it was the fabric or the stuffing of the doll. Because I got indications of possible chloroform, whether it be from the chloroform or from the material during the process of examination producing chloroform, I wanted to get a negative control doll to say if the chloroform maybe just have would come from the material itself. And I got the control doll, and it gave very, very low indications of possibly chloroform. So that with the very low amounts within the initial specimen, I was not comfortable in saying chloroform was identified in that item.
So you were able to obtain a doll, but not one of the same make and models good for a doll, but the same make and manufacturer. You weren't able to get one identical, but you got one that seemed similar. And since it had chloroform, you were not comfortable in saying that the chloroform in the doll wasn't just from its manufacturer.
He's correct in saying that I did not have a doll of the same type, but it's not that the doll had chloroform that I couldn't rule it out. It's just there was small amounts, and it was just too small for me to comfortably say that it could be identified as being a contaminant within the doll.
All right. Thank you very much. That's the only question I had.
Redirect.
So just so we're clear, sir, a coworker of yours has a child that her doll has chloroform on it.
No, that's not what I said at all.
Okay. You found another doll that had chloroform on it. Is that correct?
No, that's incorrect. I did not have the data enough to say that chloroform could be identified on either one of those items.
Okay. And that's because chloroform is found in many products.
I'm not sure where the chloroform came from. Chloroform is in other products. Whether the chloroform is in this product, I don't believe so. It may be because it uses heat and the technique, chloroform may have been produced from the material. That's why we use a negative control so that we don't falsely or incorrectly identify something that shouldn't be there.
And chloroform could be found in water as well.
If it's present in high enough amounts for us to detect and identify, yes.
I have no further questions.
Recross.
Could we approach real quickly? We may have a resolution on this.
You may continue.
Yes, sir. Dr. Rickenbach, you also, I'd like to refer you to your report back in July dealing with the Gatorade bottle and the substance that was inside of it. Do you recall those items?
Yes, I do.
Okay, and what were you asked to do in that report?
In the Gatorade bottle that was submitted, there was an unknown liquid within that bottle. Also, there was a syringe with a needle, and there was liquid within that syringe. I was asked to identify or try to identify what the liquid and the two liquids were.
Your Honor, may I publish Defense 32 for the jury?
You're offering that provisionally.
Yes, sir.
Any objections from the state?
I believe the photograph is already in evidence.
Oh, it's
without
in
objection.
evidence?
Yes.
The photograph is, yes.
Oh, go ahead, you
Yes.
may. What's the exhibit number?
32.
You may.
Do you know if this is up? Or? Can you? Thank you, sir. Is this, sir, the Gatorade bottle that you tested? Does it appear to be?
It appears to be the Gatorade bottle that the liquid was within.
Okay, and what was inside of it?
You want the results of my report?
Yes. Tell the ladies and gentlemen what you tested and what the results of your report were.
Okay, just for accuracy, could I get the report back?
I thought I gave it to you. Sorry. Go ahead and tell the jury what you found.
The liquid within the Gatorade bottle was a whitish, murky kind of liquid. While it was not fully identified, it could have come from some kind of type of cleaning product or cleaning product added to it. Additionally, a mixture of testosterone compounds were identified within that matrix.
And did you find a syringe as well?
There was a syringe with a needle on it within that bottle, yes.
And did you believe the syringe to contain, or did you find the syringe to contain testosterone?
There were within the liquid of the syringe was an oily kind of liquid, yellowish oily liquid, and within that, the same testosterone compounds were identified.
Okay. Now, in this liquidy substance, what instrument did you use to detect these items?
The testosterone compounds,
Yes.
there was a technique called gas chromatography, mass spectrometry, and time of flight mass spectrometry, which was used to identify those compounds.
And in this liquid, did you also detect very low levels of chloroform as well?
Within the Gatorade bottle liquid, the one that could have come from some type of cleaning material, low amounts of chloroform were possibly present, but they were very small amounts.
Okay. And the reason you did not report those out is because, of course, they were at such low levels and because they could have come from the cleaning product.
This is correct.
Your Honor, at this time, we would provisionally move to enter into evidence the items discussed and testified to by Dr. Rickenbach, which are specifically,
I don't believe the items are here yet. I believe the agreement was the testimony was provisional upon the items being placed into evidence at some future point in time.
Okay.
Walter. I do agree with that.
All right.
I have no further questions for Dr. Rickenbach at this time.
Okay. Cross-examination on those issues.
The amounts of, you did not report out the chloroform in your report, correct?
That is correct.
Just like with the doll, it was such a small, minor amount that was attributable to cleaning products, you didn't even report it out.
That is one of the reasons. The other reason was it was more of what compound, what are these, more of an identification, not just specifically for chloroform, and that the request was more for identification of what this compound was.
Were your identification as a cleaning product, was that based upon the mass spectra other than just chloroform, all the elements taken together?
Yes, there were indications that this was a cleaning product, and chloroform has been known to be in cleaning products, so it was not of any really surprise.
So the GC mass spec would give you a total spectrum that would convince you it was just a cleaning product.
The instrument can't identify a cleaning product. It just, based on my examination, the smell of it and the products that potentially came out, it was a possibility that it could have been a cleaning product added or from a cleaning product.
All right. No further questions.
May the doctor be excused.
Yes, sir.
Thank you, doctor. You may be excused.
My name is Karen Korsberg Lowe. Korsberg is Korsberg. Lowe is Lowe.
Good morning, Ms. Lowe.
Good morning.
Your Honor, I would ask to recertify Ms. Lowe as an expert in hair and fiber analysis.
Ladies and gentlemen of the jury, Ms. Lowe has been previously recognized by this court to be an expert in hair and fiber analysis. You may continue.
Thank you, Your Honor. Ms. Lowe, I wanted to go over some of the reports that you didn't have the opportunity to testify about last time.
Okay.
Let's start with August 13th of 2008.
If I could ask counsel to give me the FBI lab number so both the witness and I can pull out the correct report.
Okay.
Sure.
I'm sorry, could you repeat the date?
Yes. August 13th, 2008, lab number 0808 1105 and 6.
And
Yes.
six.
Yes. Do you have that report, ma'am?
I do.
Okay. Can you tell the ladies and gentlemen of the jury what you tested, where it came from, and what your results were?
There were items of clothing that were identified as coming from Caylee Anthony's closet. These items were processed for hairs and fibers, and the hairs recovered were examined for any that exhibited characteristics of apparent decomposition, and none were found.
Okay, so the results were negative.
That's correct.
Okay.
So I believe we already spoke about the other
The
two
other ones we
items.
spoke of already. Were you able to recover hairs from those items?
Yes, hairs were found.
Okay. So is it, in your experience, common that hairs are attached to clothing items or found on clothing items? I'm sorry. Found on clothing items?
Yes, it's very common to process things like clothing and bedding to recover hairs and fibers.
Okay. All right. Now let's go to your report of October 15th, 2008. And if I can have a moment, I'll give you the lab number, Mr. Ashton. Sure. Q58. Do you have that report, ma'am?
I do.
Okay. And what were you given here and from where?
This was debris that was identified as coming from a trash box, I believe, from the vehicle. Again, this was examined for any hairs exhibiting signs, characteristics of apparent decomposition, and none were found.
Now let's go to October 21st, 2008. And can you identify those items?
In this
I'm sorry, Q25. Sorry.
Okay. In this report, I dealt with specimen Q25.1. Was actually a hair recovered when an item in the laboratory was examined by another examiner. This hair was examined for characteristics of apparent decomposition, and none were found.
Could we have an identification of where this item came from?
Yes. Does it state in your report where the item came from?
It's Q25 was one of the pieces of trunk liner.
Okay. So this was an item that was found on the trunk liner, a hair that you examined that did not show any signs of apparent decomposition.
That's correct.
Now, on November 6th, for council, it's lab number 08-110-4009. Can you tell us where these items came from?
They were identified as coming from the vehicle.
Okay. And what were they, and what did you do, and what were the results?
It was 4 items of debris. 2 were identified as coming from a trash bag, 2 from paper towel. Again, they were examined for hairs with characteristics of apparent decomposition. On one of the items, no human hairs were found, and the remainder, the human hairs that were found, did not exhibit characteristics of apparent decomposition.
Now, I'd like to take you to November 6th. Now, June 25th of 2009.
You may.
Okay. June 25th, 2009, you received quite a bit of items of evidence, did you not?
Oh, this report covers 5 different laboratory numbers, so yes, there's quite a bit of evidence.
Okay. And let's start from the beginning and work our way through. Okay. The first section shows items from the trash. Is that correct?
That's correct.
And that would have been trash recovered from the vehicle.
That's how it was identified.
Okay. And what did you do with those items? Well, actually, count the number of items and then tell the jury what you did and what your results were.
As far as items that were identified as coming from the trash, there are 12. Items that are just identified as coming from the trunk, there are 8. These were all just debris, so items that were collected, what looked like hairs and fibers were
I'm
collected.
sorry, Ms. Lowe. Can you speak closer to the microphone?
Sorry.
I'm having a hard time hearing.
These items were collected either from trash or the trunk, as how they were identified, and these were examined for any hairs with characteristics of apparent decomposition, and none were found.
Okay, so none of the items in the trash contained any, they all came back negative, the test for that.
If hairs, some of the items actually didn't have human hairs present, but of the items that did have human hairs present, none of them exhibited characteristics of apparent decomposition.
Okay. And then you received some items from the medical examiner's office.
Right, the next laboratory number deals with items that were either from the medical examiner's office or identified as coming from the residence.
Okay. Let's start off with the medical examiner's office. What did you do with those items?
Mr. Shaw handled the hair exam portion of this. So these items, I examined any fibers that were present and compared them to known samples of the trunk liner and spare tire cover, as well as some vacuumings recovered from the vehicle to see if there were any associations, any fibers that were consistent between the two, and I did not find any.
Okay, let's break that down a second. You took fibers that were recovered from items that were found from the scene or from the medical examiner's office?
That's correct.
Okay. And these were known to be associated with Caylee Marie Anthony.
That's how they're identified.
And you checked the fibers from those items and compared them to the trunk of the car.
Two fibers either comprising the trunk liner and the spare tire cover, or fibers found in vacuumings.
And there was no match between those fibers.
There are no fibers consistent between the two, correct? Or between the sets of items.
Okay. And then you received some items from the residence, did you not?
That's correct.
Okay. And what did you do with those items?
At this point, the vacuums were not examined. Those were covered in a later report when they were resubmitted. Also, with this submission, I was asked to do a fabric comparison between the fabric portion of duct tape identified as being recovered with the remains, and the fabric portion of a piece of duct tape that was identified as coming from the residence. To do a fabric exam, first you would look to see, you're looking at the color, the construction, and the composition. Are the colors the same between the two pieces of fabric as well as the fibers themselves? Are they constructed in the same way, and are they made of the same types of fibers? These particular fabrics were woven, so the fibers intersect. There are yarns that run horizontal and vertical, so I'm looking to see, do they intersect in the same way? Are there the same number of yarns per inch? And then finally, are they comprised of the same materials? In the duct tape that was identified as coming from the residence, the horizontal yarns contain both polyester and cotton, and the vertical yarns contain only polyester. When I examined the tape that was identified as coming from the scene, the horizontal yarns only contained polyester, so I didn't find that cotton component. Based on that examination, I concluded that they were actually dissimilar and not consistent with coming from the same source.
Okay. And then you receive, what about the other items from the residence? Did you receive a vacuum cleaner? Did you receive some vacuum cleaners from the residence?
I did. At this point, they were not examined, and that's covered in my next report.
Okay. And why were they not examined?
They were collected months later, and they were vacuums from the residence, so I questioned whether or not anything that I would find would really be probative, but they were resubmitted at a later date, and I did examine them later.
Okay. And then you received some other items from the medical examiner's office, is that correct?
That's correct. The next submission contains items that were identified as coming from the medical examiner's office, as well as the scene.
And what did you do there?
For these items, I examined hairs and compared them to the FBI laboratory identifier Q59, which was the hair mass. At this point, we're using this as a known sample.
Could we have the identification of which item she's speaking of?
Sure, the hair mass.
Yes.
To what? But she's talking about comparing it to something, and I think counsel needs
I will.
to make clear to the jury what it is she's comparing it to, because we're going kind of quickly through things.
Kind of slow it down so they can follow.
My apologies. Yes, sir. 217, and what did you compare them to? Or you didn't do the actual comparison, did you?
To the items in this laboratory number, I did.
Okay. And what did you compare them to?
There were a number of items of clothing, debris, plastic that were identified as coming from the medical examiner's office, and then numerous pieces of plastic and a blanket, a bag, a tape, and collection paper that was identified as coming from the scene, or were identified with items recovered from the scene.
Okay. And the items that you received from the scene, what did you do with those?
These items were examined for hairs that were present. These hairs were compared to the Q59 hair mass, which again, we're using as a known sample for the victim, to determine if there were any hairs that were dissimilar to the hairs in this hair mass.
And did you find any hairs that were dissimilar?
There was one Caucasian head hair that was found on a collection paper, which was microscopically dissimilar to the hairs in the Q59 hair mass. So this hair is not consistent with coming from Caylee Anthony.
Okay. And that hair that you found, did you then do tests from or pull hairs from crime scene investigators to eliminate them as potential contributors to that one hair that you found?
Objection, Your Honor. We're going to need items and evidence and identification of individuals on this issue.
I think she
This
could.
approach. Ladies and gentlemen of the jury, we're going to take about a 5 or 10 minute recess to take care of some matters right outside of your presence, and we will be back with you. We'll take a 5 to 10 minute recess. Okay, you may be seated. Okay, have y'all been able to come to any sort of agreement on the issues that we've been discussing?
Yes, sir, I believe we have.
We have. The agreement is that counsel will be able to ask the witness the names of the individuals, but the agreement is that not every individual that has contact with it was tested.
Okay, ready to proceed?
Yes, sir.
All right, let's return to jury. Okay, state recognized presence of jury.
Yes, sir.
Defense,
Yes, sir, we do.
you may continue, Mr. Baez.
Thank you, Your Honor. Ms. Lowe, I think we left off that you found an unidentified Caucasian hair. One was found at the scene, correct?
One was found on FBI Q number 107, which is identified as collection paper from items from the scene.
Okay. And do you know what those items were?
Specifically, what was identified with that paper now?
Yep, okay. Now, that prompted you to then do a further examination of other individuals who were there at the scene, correct?
That's correct.
And refer to your report on March 30th, 2008. I'm sorry, not 2000. That would be 2009.
The 2010 report.
I'm sorry, 2010. Okay. And can you tell me who the individuals were that were tested?
I can give you the names. I don't know where they work.
That's fine, the names.
Okay. There was a head hair sample identified as coming from Robin Maynard. It's Maynard. One from Christine Mankiewicz, Mankiewiczz. Melissa Cardillo, Cardiello. Sarah Coble, Coerbel. Carrie Wood, Wood.
Is that Kelly Wood?
Oh, I'm sorry. Yes, Kelly. Gerardo Blouse, Bloise. And Jenny Welch, Welch.
Your Honor, by stipulation, both the state and the defense agree that this is not a complete, exhaustive list of everyone that had access to the scene.
That's correct.
Thank you.
Okay. And, ma'am, were you able to identify or exclude these individuals as potential donors of this hair?
Yes, the Q107 hair was microscopically dissimilar to the head hair samples that I've previously identified, so it was not consistent with coming from any of these individuals.
So currently that hair is unidentified. You haven't done any further tests to confirm whose hair that is, correct?
It was dissimilar from the Q59 hair mass. The individuals that I've mentioned, it was also compared to the head hair sample identified as coming from Caylee Anthony, and it was dissimilar to all of those known samples.
Did you compare it across anyone else other than Caylee, Casey, and these crime scene people?
These are the known samples that I was given.
Okay. Okay, going back to your June 25th report of 2009, were there any other items that, actually, I'm sorry, I want to bring that up. Were there any other items that you received that you inspected?
And this report covers items that were identified as coming from the scene, some additional items from the vehicle, the residence, and additional items from the vehicle.
Okay. And what did you do with those items?
The items from the scene were examined again for hairs that exhibit characteristics of, no, excuse me. Items from the scene were compared to, any hairs recovered were compared to the Q59 hair mass to determine if anything was microscopically dissimilar. Aside from the Q107 hair, the hairs were either not suitable for comparison or were consistent with the Q59 hair mass.
Now, you've issued 9 different reports in this case, correct?
That's correct.
And excluding the Q59 hair mass that we know came from Caylee from the site, how many hairs would you say you inspected in this case that did not have any signs of apparent human decomposition?
That's not a number that I count, but many of the items had hairs present, whether or not they were suitable. So there could be hundreds of hairs, and there was only the one.
Okay. So out of a potential of hundreds of hairs, you only found that one.
Objection, asked and answered.
Overruled.
That's correct.
And these are from different locations, not including the home, the car, and the site off Suburban Drive.
The items that would have been examined for hairs of apparent decomposition would have been limited to the residence and the vehicle.
And that includes Casey's entire closet.
Objection assumes a fact which are not in evidence.
Sustained.
That includes the clothing items that were given to you.
They were identified as coming from Casey's closet, correct?
Okay. I don't believe I have any further questions at this time.
Cross-examination.
The one hair that counsel spent some time talking to you about, the 107 hair, you have no idea. It came from collection paper from some item, but you don't know what item.
That's correct.
You don't know what relationship it had to the scene. You just know it was identified collection paper from something from the scene.
That's correct.
And the hair that you found, which had the apparent decomposition, was reported as being found in the defendant's car trunk.
That's how it was identified, yes.
Do you know whether during the period of time between June 16th and July 5th, let me just rephrase that. You don't know during the period of June 16th to July 15th where Caylee Anthony was living, do you?
No, I don't.
So you don't know whether she was living at the house where the clothes were collected. You don't know.
I don't know.
No further questions.
Any redirect on those issues?
Ms. Lowe, if you had been given items from where Caylee Anthony was living during those 30 days, would you have tested those?
If they were available, I could have examined them for the same reasons that I examined the other items, yes.
But you were never given anything, were you?
No, sir.
No further.
May the witness be excused.
As far as the state's concerned,
Thank you, Mr. Lowe.
Thank you.
is she excused permanently or subject to recall? I know she'd probably want to know.
Excuse means excuse. Nobody's put any
Yes, sir.
provisional requirements.
Thank you.
Subject to recall, but can she return back to her? Yes, she can return back home. Okay, ladies and gentlemen, this concludes our presentation for the day. As I indicated to you, I have an obligation, and I will see you in the morning, and we will extend our working hours on Saturday. Okay? All right. Thank you very much. On Friday, Mr. Baez, I'm going to ask the defense to give me their best guesstimate of when you think you will conclude your presentation. This is not designed to rush you. It's just simply giving me an idea. And the reason I'm asking the question is the state has indicated in conversations at sidebar where you were present that they intend to present some rebuttal testimony. So I want them to have an idea when they would need to be prepared to have their rebuttal. And we'll go from there.
Happy, Your Honor, to give everyone that professional courtesy.
Okay. All right. Anybody have any okay. I will see you in the morning. We will start testimony at 9 o'clock. If you have any matters, we will take those up at 8:30. Huh?
Just thank God it's Wednesday.
And there's Thursday, Friday, and Saturday. And Monday, Tuesday. Pardon? It is what it is, Mr. Mason. Okay, court will be in recess until 9 a.m. for testimony tomorrow, 8:30 for other matters.